If you've ever had a Pisco sour cocktail, you'll know Pisco as a grape spirit popular throughout South America. But here's the legal question. Can Peru register Pisco as a certification trademark in Australia and effectively control who is allowed to use that name? And perhaps, more importantly, what happens when another country says the name belongs to them too? Welcome back to Elise Explains IP. I'm your host, Elise Dijkstra, trademark nerd, lawyer, and general all-around crazy person. Today we're talking about a trademark dispute that involves international politics, centuries of history, national identity, and, unsurprisingly, a large amount of alcohol. The case is Republic of Peru, brackets Peruvian State, and Registrar of Trade Marks, 2026 FCA 791. I'll post a link to the full judgment in the show notes. At the centre of the dispute is a single word. Pisco. P-I-S-C-O. So, let's unpack it. Pisco is a spirit that's made from grapes. Peru says it originated in Peru and has been produced there for more than 450 years and is deeply tied to Peruvian culture, history and identity. Peru regulates exactly how Pisco is made. It has rules covering the grape varieties that can be used, where the grapes must be grown, how the spirit is distilled, how it is labelled, and who can use the name Pisco. In many ways, it's similar to products like champagne, Parmigiano Reggiano, or Scotch whisky. These products are associated with a particular place and a particular method of production. In trademark language, this type of protection is often achieved through a certification mark. It can also be achieved through international agreements like geographical indicators and limitations on geographical indicators, but a certification mark is a great way to do it as well. So, what is a certification trademark? Most business owners are familiar with ordinary trademarks. A trademark tells consumers the source of the goods or services. When you see the Nike swoosh, you know who made the product. Certification trademarks work differently. They don't indicate who made the product. Instead, they indicate that the product meets certain standards. Those standards might relate to quality, manufacturing methods, ingredients, or geographical origin. We looked briefly at geographical indicators in episode 30 with Armando when looking at tequila and mezcal in Mexico. For example, multiple producers can use the same certification mark if they satisfy the certification rules. That's why certification marks are commonly used to protect regional products or very specific types of products. So, back in 2019, Peru applied to register Pisco as a certification trademark in Australia for alcoholic beverages. The proposed rules were strict. Only authorised producers complying with Peru's regulations could use the mark. The spirit had to be produced in specified regions of Peru and according to the prescribed production methods. On the face of it, sounds pretty straightforward. If champagne can be protected, why not Pisco? But there was a problem. Chile also produces a spirit called Pisco. In fact, Chile has been producing and exporting products labelled Pisco for a very long time. The Australian Trademarks Office looked at the evidence and said, consumers in Australia understand Pisco to refer to a type of spirit produced in both Peru and Chile. If that is true, then granting Peru exclusive certification rights could prevent legitimate Chilean producers from describing their products in the way they have traditionally done so. The Trademarks Office refused the certification trademark application. Peru appealed to the federal court. This case wasn't really about who invented Pisco. The court wasn't being asked to determine centuries of South American history. Instead, the question was much narrower. Potentially simpler, but maybe not. The court had to decide whether the word Pisco was capable of distinguishing goods certified by Peru from goods that were not certified. In other words, when Australian consumers see the word Pisco, what do they think it means? Do they think, yes, this is a Peruvian product made from a particular region under particular standards? Or do they think this is simply a type of spirit that can come from both Peru or Chile? The distinction mattered enormously. The court examined a huge amount of evidence. There were dictionaries, there were historical materials, there were promotional campaigns, there was evidence about imports into Australia, there was evidence about how bottles were labelled. One interesting point was that Australia had imported enormous quantities of Peruvian Pisco over many, many years. The evidence suggested that around 650,000 bottles of Peruvian Pisco had entered Australia before the relevant date. Many of those bottles clearly identified Peru as the country of origin, the denomination of origin, and the authorization number issued by the Peruvian government under Peru's regulatory system. The court considered that repeated exposure to these products was likely to educate consumers about the connection between Pisco and Peru. The registrar had relied heavily on dictionary definitions, suggesting that Pisco was a spirit produced in both Peru and Chile. But Justice Burley of the Federal Court wasn't entirely persuaded by this. He noted that many of the sources in the overseas publications, they weren't necessarily reliable evidence of how Australian consumers understood the word. The court ultimately concluded that Australian consumers were more likely than not to understand Pisco as indicating a location or region of origin in Peru. That finding became decisive. Justice Burley held that Pisco was inherently adapted to distinguished goods certified under Peru's certification system. The court overturned the registrar's decision and ordered that the application proceed to registration. Importantly, the court noted that registration doesn't end the story. The mark can still be opposed, and future evidence could still be considered, potentially submitted on behalf of Chile and the Chilean Pisco producers. At first glance, this might seem like a niche dispute about a spirit most Australians only encounter in a random cocktail bar. But the principles are much broader. This case is really about commercial value. Names matter. Origins matter. Stories matter. Consumers often pay more for products because of where they come from. Think about champagne, Scotch whisky, Parma ham, Roquefort cheese, or Darjeeling tea. The name itself becomes a commercial asset. The geographic reputation becomes part of the brand. That's exactly what Peru was trying to protect. So what are the lessons for business owners out of this case? There are 3 practical lessons here. Number 1, geographic reputation can be intellectual property. Many businesses focus only on logos and business names, but place-based reputation can also be incredibly valuable. It is pretty difficult to get in Australia, but it can be really incredibly valuable. If customers associate your products with a particular location, process, or tradition, that reputation may become protectable. Number 2, certification marks are powerful. Certification marks are often overlooked. They're not suitable for everyday businesses, but industry groups, associations, and regional producers should be paying attention. A certification mark can create trust and preserve standards across an entire category of products. Number 3, as we've talked about before, the evidence matters. One of the most interesting parts of this case was how much weight was given to evidence of consumer understanding. Sales volumes, labelling, marketing, consumer exposure. All of these factors influenced how the court viewed the meaning of the word Pisco in Australia. The lesson is simple. If you're trying to establish rights in a name, your evidence matters. The story you can prove is often more important than the story you can tell. This case is a reminder that intellectual property isn't always about inventions or logos. Sometimes it's about history. Sometimes it's about culture. And sometimes it's about a single word that 2 countries have spent decades arguing over. And we'll come back to this when we look at Manuka honey, because that's a doozy as well. For Peru, Pisco is more than a drink. It's part of its national identity. And at least for now, the federal court has recognised that Australian consumers are likely to see it that way too. That's all for this episode of Elise Explains IP. If you'd like help protecting your trademarks, considering a certification mark, branding, or any of your other intellectual property assets, you can book a free strategy call with me via my website, www.elisedijkstra.com. And until next time, own your own ideas. Thanks for spending time with me on Elise Explains IP. If you picked up something useful, hit follow, subscribe, leave us a review, or send it to a founder friend who could use this information. And remember, this is general information, not legal advice. If you do want help with your IP, you can book a strategy call with me at any time via my website. The link's in the description. So until next time, own your own ideas.